Lordship, with the consent of opposite party, in connection with item number 25 of today's course list, I'd like to request this honorable court to kindly fix the matter after 3 weeks, Lordship, owing to personal difficulty of the main conducting counsel,
You are Mr.
J. Lomi.
J. Loman. J. Loman.
J. Loman.
J. Loman. Learned counsel appearing on behalf of Mr. AKC Learned counsel for the appellant. Come on the consent of the other side, press for adjournment of the matter. Mr. Praise the Lord. List this matter after 3 weeks.
Lordship, I beg to mention item number 14.
14.
I am filing counter affidavit on behalf of respondent number 5 today.
Yes.
I've taken consent from the
Okay.
parties.
On the consent of respondent, Mr. R. Koyu, Learned counsel for the respondents. Press for and is granted 3 weeks time to file affidavit in opposition.
Much.
This after 3 weeks.
Mayor, please. Lordship, I beg to mention item 23 and 24.
23.
For supplementary hearing on behalf of B party. On behalf of B party. Your Lordship. Item number 23 and 24.
B 13.
B party. Your Lordship.
1 week.
The maternity leave on 27 of this month. I have already taken the consent from the other parties. Your Lordship.
What is this?
And this is your Lordship.
Compensation.
Yes, Lordship.
Have you filed the affidavit?
Yes.
What is there? Anyway, on the joint prayer of the Learned counsel for the parties, list this matter on 27/05/2020.
Value of that.
My lord, I beg to mention item number 19, my lord.
19.
Yes, my lord.
Yes.
My lord, here I am required to file the affidavit, my lord. Yet parawise comment I will to receive, my lord.
And
Can
your
you please
lordship,
after,
item number 19.
yes.
Yes.
Okay. So lordship, there is an interim, so that may be continued.
Okay.
Maybe list
On the
after
prayer of Mr. T. Tagum, Learned counsel for the respondent, list this matter after 3 weeks.
2 weeks.
2 weeks, so as to enable him to file affidavit in opposition.
Yes, my lord.
MSK Choton,
Okay, Chotan.
Learned counsel for the petition is present. List
Give
after
it.
2 weeks.
Obliged.
May I please, Lordship?
Yes,
I beg to mention item number 8, Lordship.
8.
Lordship, here kindly, Lordship may allow
And in that
to
case,
withdraw
item
this.
19 interim order, earlier was still continue, item 19. Yes,
Kindly allow me to withdraw this petition, Your Lordship.
on the prayer, Mr.
T. Gatso.
T gets, no, Mr. T gets, Learned counsel
The petitioner.
for the appellant submits that he may be allowed to withdraw this present appeal. Mr.
Yeah, I am for the respondent.
MS.
I have no objection.
J. Doji, Learned legal aid counsel
Yes.
is present. Praise the Lord. Accordingly, next para, the regular first appeal stands closed on withdrawal.
My lord, I'd
Yes.
like to mention item number 21.
21.
The leading counsel is out of the station, so kindly extend the date.
On the prayer of MS, so and so Learned counsel, appearing on behalf of Mr. Arsoner, Learned counsel for the petitioner. List this matter after 4 weeks.
May your lordship, I beg to mention item number 18 on behalf of NPATA, your lordship.
Item
18,
18.
yes, your lordship, this matter was supposed to be listed after 3 weeks.
Yes, this is connected with item 17.
Yes.
Yes, Your Lord.
We'll see.
Let it be your lordship. We are.
It's in orders, we'll see.
My
Yes.
senior, he is out of station.
No.
Call him back. We're
He's-
waiting for him.
He's out of
They have the interim is okay, lordship.
We'll see. You be there. It's
Yes.
listed for orders. We'll see. What the orders to be passed? Sir, what is this?
May I please, madam? Madam, this is a.
Go and settle.
My
Before
lord?
the Gaupura, what is this?
Madam, because my lord, the Gaura is also The maternal uncle of the my lord, respondent number one, my lord.
Yes.
My lord, and my lord, section 17(1) of the Arunachal Pradesh Civil Code Act, my lord.
Yes. very
Bars, my lord, the village authority,
good. Have you annexed that?
my lord, the act.
Yes. Have you annexed?
No, my lord, I have the copies, my lord.
You have not taken the bridal price.
No, no, my lord.
You must.
In fact,
It's the customary practice.
no, my-
We are dishonoring the customary practice.
the marriage has been solemnized in terms of the my lord, bridegrooms, my lord.
Okay. In the
And,
Indian custom, it is not
no,
permissible.
it's called
It's
kepel, my
not
lord.
permissible.
Yes, it's called kepel, my lord.
Kepel,
Kepel, my lord.
two squirrels
Two
and
squares and
one full jug of
Yes, my
that
lord.
rice beer, white rice beer.
Yes, my lord.
That's all.
That's all, my lord.
Yes, section 17. Yes,
Yes, ma'am. My lord, the complainant, my lord, the head Gawapura, the village authority is the my lord, maternal uncle of the my lord.
complainant,
That's what complainant, my lord.
real maternal.
Real maternal.
Otherwise, in the gallows, everyone is
But my lord,
neatly connected. Somewhere or the other.
but he is the real maternal uncle.
So no judicial officer, authority of customary court shall try any suit to, or in which he or she is a party or personally interested. Only on this ground.
And my lord. from
Otherwise, you
the-
have no problem attending the kebab.
No, my lord, I have a problem, my lord.
Okay.
Because my lord, we have represented before the village authority, my lord,
Okay.
by my lord, respondent numbers 2 data also.
So we'll issue notice.
And I pray that till the returnable date, my lord, someone may be stayed.
Yes. Or Mr. Arsoikia, learned counsel for the petitioners.
My lord.
Next para. By filing this application, the petitioners have put to challenge the impute Keba Purwana dated 06/05/2024 issued by the head Gawapura,
Head Gawapura
head Gawapura
of Seren village.
of head Gawapura of Seren, SEREN, Seren village, North Siang district. Lower Siang district. On the ground that in essence, there is no civil dispute between the parties for trial. And also, and also on the ground of, and also the, in violation of Arunachal Pradesh, provisions of Arunachal Pradesh Civil Code Act 2021. Issue notice returnable by 4 weeks. It is no the petitioners to take steps for service of notice upon respondent number 1 to
1 and 2, my lord.
1 to 1 and 2. Whereas that was within within 2 days.
My lord.
Third on interim prayer. Next prayer. Mr. Arsoike, learned counsel for the petitioners, referring to the section 7 of section 17 of Arunachal Pradesh Civil Courts Act 2021 submits that since the head Gaubura,
Head government.
who has issued the Purvana, is the maternal uncle of the maternal
Maternal.
of the complainant,
The
complainant
respondent
of the
number one.
respondents,
Respondent number one, madam.
complainant public respondent number 1. He cannot, he's not, he's barred from taking up any shoot. As he is a party or personally interested in the matter. Mr. That apart. Since the complaint is that apart, the complaint is with regard to allegation of acceptance of bridal price
Madam.
by the petitioner, number 2 or 3. Number 1.
Number one and two.
Number 1. In the marriage, pursuant to the marriage solemnized between the respondent 2 and 3.
Hmm.
2 and 3.
Madam.
2 and 3 are the husband and wife.
No, madam.
Respondent number,
Three is the daughter, my lord,
uh,
and my lord,
respondent number 3 and
husband is not
one,
a,
he's not a party.
not a party.
1 Sri
Madam Minkeng,
Minkeng Yirang,
Irang, madam.
Minkeng Yirang. Mr. Next paragraph. Having considered the submissions and the perusal of the section 17 of the Arunachal Pradesh Civil Courts Act 2021, it is said that the
लिखे रखो, हाँ.
an authority of customary court is debarred from try any suit in which he or she is a party or personally interested. Since the petitioners on oath has stated that the Gaubura who has issued the Purvana, impugned Purvana that is 6/05/2024 is the maternal
Maternal.
uncle of the complainant public respondent number 1.
Two, madam.
Respondent number 2.
Oh, so one, madam.
You said respondent number 1. Respondent number 1. Number. Prima facie, the head Gaubura, being an authority of the customary court, may not be permitted to try the suit, even if there is a tribal, even any dispute, even if there exists a tribal civil dispute. In view of the above, till the returnable debt, the imputed Purvana 06/05/2024 issued by the head Gaubura, Syrian village in the lower Sivan village still remains suspended. That's all. This after 4 weeks. Returnable 4 weeks, right? Issue notice, call for the, what is
Okay.
this? Case diary.
Lordship,
Well,
yes, Lordship. The scan copy of the case diary.
Case
Oh,
diary.
no, sorry, LCR, Lordship.
It's
In the state of
TCR.
TCR, Lordship.
What
Yeah,
is
it's-
TCR?
Trial court record, Lordship.
Okay.
Lordship, this is a
How
stage of
to-
final hearing, Lordship.
What is the section?
380, man.
380.
My lord.
What
The
you-
boy was 18, 19 years
What you
old.
have stolen?
One Philips
Huh?
radio, my lord.
What?
One Philips radio, 2,000 rupees and two local bangles.
It's antique nowadays.
My lord.
It's an antique piece nowadays.
No, my lord, that was not costly, my lord. It was already been returned in 2019, my lord, when the
Okay.
first Kaba was held, my lord.
We'd love to have that Philips radio now.
And at that time, my lord, 40,000 fine was imposed in 2019, my lord.
Okay.
But he could not pay the fine because of, since the boy is only a laborer, my lord.
Now you wanted to pay. You want to pay now.
They have already paid, my lord. Recently, my lord, in the 15th of April 2024, my lord. Now the trial is already almost finished, my lord. And the petitioner number 1, who is the accused, my lord, he has admitted to everything also very fairly, my lord.
Then you will be convicted.
My lord. That's why, my lord, they are here before this honorable court, my lord.
Anyway, at least you notice. Heard Mr. Disoki, learned counsel for the petition. This is an application under section 482 CRPC cover 1973. Praying for quashment of GR case number 29 of 2020 under section 380, IPC, pending before the pending before the Chief Judicial Magistrate, Dapuriji. Call for the scanned copy of the trial court record. Mr. MSL Hagelan additional PP appears on behalf of the state. Then
My lord, I'm praying
It's
for,
a-
my lord,
uh,
praying for staying of the further.
it's only for argument,
Yes, final argument is only remaining though, my lord.
pending production of the trial court records. Usually the scanned copy of said, the proceedings of GR case number 18 of. No, you said.
Oh, no, my lord,
29. Which one is correct?
This, my lord, this is it. In fact, 18 is my lord, PS case number. In this inadvertent mistake, my lord. I may be allowed.
29, huh?
29.
Under section 20, under 29/2020, under section 380 of IPC. Pending before the Chief Judicial Magistrate command. The shall remain state. Shall remain state.
Look,
Yes,
that,
sir.
that 18, my lord, I may be allowed to correct it by hand, my lord. It should be 29. Of like,
Problem, sir.
List after
Uh,
3 weeks.
2 weeks, Lordship.
3 weeks. Offer the land, Mr. offer the land council for the petition. This is the application same, huh? For quashment, praying for quashment of the FIR.
FIR as well as the charge sheet, my lord.
FIR. Number 49 of 2022, that is 02/11/2022. And the charge sheet number 03 of 2022, that is 15/02/2026, and it's 447, 448, 506, public 34 IPC, corresponding to GR case number 894 of 2022. Pending before the
CJ, my lord.
Chief Judicial Magistrate, UPR,
My lord.
Capital Complex, UPR.
My lord.
Call for the scanned copy of the trial court record. Mr. T at the learned edition PP. And appear, entered appearance on behalf of the state. So proceeding will stay.
My lord. There's an
There will be proceeding after
Yes.
filing of charge sheet.
Charles Prime, dear Lordship.
Okay. Pending production of signs, trial court records. Proceedings of GR case number.
894.
You have not given, you have prayed for 894,
894 stroke 22.
of 2022, pending before the Chief Judicial Magistrate, Cabinet Complex here, shall remain suspended. List after 4 weeks.
4 weeks.
Okay.
Deeply obliged.
Suspended.
Your Lordship,
Yes.
this is a joint petition, Your Lordship, in connection with 380 and 34 of IBC.
Then in that case, the second item 2, you said on the basis of joint petition filed by the so and so. Item 2. Jointly filed by so and so on the basis of the compromise, that you add in the first para. Yes.
Your Lordship, this is joint petition in
Hmm.
connection with Chimpu PS under section 380 and 34.
Yes, same order.
Your Lordship, the
Posting of the GR case number 1227 of 20. One
122(7).
Is it correct?
1227 of 21.
Is it correct?
They have, Your Lordship,
Of 20.
mentioned it as 1227, corresponding to
Under
Chipu-
section 380, corresponding to Chimpu PS case number 47 of 2021, under section 380 of the 34 IPC. Call for the scan copy of the transport record. Mr. T. Telan Ellison PP appears on behalf of so and so. Pending production so and so, same. GR case number. Proceedings of GR case number 122(7) of 21, pending before the Chief Judicial Magistrate, Capital Company shall remain suspended. List after 4 weeks.
Your Lordship, there I have interim prayer also.
I have granted already.
already said. Deeply obliged.
Item number 5.
Your Lordship, this matter will be done through the VC by senior counsel.
Yes, sir.
Followed by the earlier order dated 10/5/2024, Mr.
Oh, yes.
was,
My instruction is, my lord, will file affidavit, my lord, detail affidavit.
No. You are supposed to place, obtain instruction whether joint verification has been carried out.
To that respect, my lord, though not yet done, madam.
You do it.
My lord, this is the one pack, second package, my lord, wherein, my lord, the contractor is the same, my lord, my lord, the contract agreement. But here the only difference is, my lord, directly there is a, my lord, the agreement made between the, my lord, the other, the same part, first party. My lord. So therefore, my lord, this is yes,
No. There may be a dispute regarding whether you have constructed or not.
yes, my lord.
I mean, the petition.
Correct.
Whether you may not have that privy to that, but it is maybe the petitioner with the main contractor. But then similar method, this court has directed for verification.
True, my lord.
You make a verification,
My lord.
carry out a verification.
Yes, ma'am. In
What
fact,
is there, we'll see.
yes, my lord. In other package, my lord, verification report has already been submitted, my lord, that will file affidavit. My lord. In this respect,
Do we need to direct for verification?
my lord, that will be, my lord, yes, to apprise the, my lord, the other authorities also to make my lord, carry out the verification.
Yes, what is that earlier order of this court?
my lord, at
verification.
page 253,
253.
relevant from my lord 257.
257. Heard Mr. P.J. Sekia, learned counsel, learned senior counsel assisted by Mr. So-and-so, who appears pro BC. List of this court on 1005/2024 directed the learned DAJ to obtain instruction as to whether a joint verification has been carried out in the present matter, considering that a similar matter being WPC number 03 of 2024 is pending which is pending waiver.
Yes, my lord,
This court-
3 is also pending.
This court has directed to submit the verification report within 3 weeks. Now, today, the learned DSJ submits that the no verification has been carried out in respect of the present petitioner. In respect of the present matter. However, he has an instruction to file a response opposing the grievance raised by the petitioner. Please do. Next paragraph. Considering that the nearly similar matter in the case of in respect of writ petition. What is the writ petition? 23.
22, 24, madam.
3 AP of 24.
The 3 of 2024, filed by one Messrs.
Petrodump.
Dumpum Enterprises. The court has directed for joint verification
Of the work executed by
by
the
order dated 04/03/2024, comma. The respondents and the petitioners are directed to carry out joint verification, comma, verifying the extent of work done by the present petitioner. And placed on record by way of affidavit within 3 weeks
Madam.
from today. Should we issue notice? Notice
Yes,
has been issued.
Yes, madam.
yes, madam, this is an interim.
Notice
measure.
may be-
Then in that case, before that, you will just write, issue notice returnable by 3 weeks. You are appearing for all the response.
Madam, I am
No.
for the 1 to 4,
Mr.
madam.
Since Mr. M. Katolan, DSGI, appears for respondent, entered appearance and accept notice on behalf of,
1 to 4, madam.
and then you write 1 to 4.
Respondent number
And
1 to 4.
MSG at the learned additional senior government advocate have entered appearance, both, huh?
No,
And accepted
5 and
notice
6, 5, only 5.
on behalf of the respondents, comma, a list of, comma, no formal notice in this, however, extra copies be furnished to the learners council for the response.
Chairman.
Then you write that, huh?
But I'll be taking
Please
steps
after
for
for it.
respondent number 6 and 7, madam.
6 and 7 is a private.
Private mail. So I'll take steps.
Okay, then you add that to take steps for petitioners to take steps for respondent number 6 and 7. Yes,
Obliged.
Deputy President.
Item number 6.
yes, sir. Yes, your lordship. Page 32. Disqualification.
Yes, Your Lordship, this is a disqualification matter and the true type copy is at 32A, Your Honor, page number 32A.
Yes,
May I read out?
yes.
Whereas a complaint was received by the member secretary on 8th April 2024, and the same was referred to the undersigned within 24 working hours on 8th April 2024 itself. The complaint was lodged by 3 ZPMs, namely Ms. Chathang Loang, ZPC Tirap, number 2, Sri T. Halang, ZPM Bari Basit, and 3, Ms. Sara Wanglat, ZPM Borduria, to the effect that Mrs. Viram Mate, ZPM Kapu ZP block, has shifted from Indian National Congress ZPMs to BJP party without fulfilling the required quorum of 2/3 majority to be considered as merged, as laid down in section 5(2) of the Arunachal Pradesh Local Authorities Prohibition of Defection Act 2006, thereby violating section 3 of the Arunachal Pradesh Local Authorities Prohibition of Defection Amendment Act 2006, and as such, prayed for her disqualification from ZPM seat as per provision of law. They have submitted evidences in support of the claim as part of the complaint. And whereas Mrs. Viram Mate has also submitted written reply to the complaint, which has also been examined. Whereas based on the above complaint and the reply submitted by Mrs. Viram Mate, the following are noted. Number 1, there are only 2 members of INC in the ZP concerned, and as such, defection of one does not fulfill the requirement of 2/3 members from exemption under section 5(2) of the Arunachal Pradesh Local Authorities Prohibition of Defection Act 2006. 2, ZPM Srimati Viram Mate along with other BJP ZPM members came to the office of the undersigned in
Prohibition
person
Act
on 4th April 2024 to submit the application for no conference motion against Ms. Chathang Loang,
Local Service Authorities.
ZPC,
2006.
and she has signed the said application.
Yes. Local authorities. Prohibition, defection. Yes, which volume?
I have a Xerox copy of the same. Now,
This is amendment 2006.
2006, there is an amendment, very short amendment.
2003.
This is originally 2003, 2003.
Okay.
2006 is the Amendment Act.
Yes.
The last page is the amendment for it. Now,
Yes.
yes, Your Lordship, the last paragraph. Hence, based on the above 2 facts, I am satisfied that the actions of Mrs. Viram Mate are covered by the provisions of section 3 of the Arunachal Pradesh Local Authorities Prohibition of Defection Amendment Act of 2006. Next page. And whereas under the provisions of section 6(2) of the Arunachal Pradesh Local Authorities Prohibition of Defection Amendment Act 2006, it is hereby decided that she is disqualified as being a ZPM of Kapu ZP Block Tirap. Now, Your Lordship, this is an order which has been passed by the Deputy Commissioner Khonsa on 29th of April 2024. The first ground which I am seeking the indulgence of this honorable court is that the principles of natural justice has been blatantly and flagrantly it has been violated. Although, Your Lordship, notice has been issued to me. Of course, notice is the first limb of natural justice, needless to say, Your Honor. Although notice was issued to me requiring me to appear on a particular day, I did appear. Finally, I appeared. I appeared on all the dates.
Please sit down. Please take your seat. Madam, take your seat. Where are you traveling yourself?
Your Lordship, although notice was issued to me requiring me to appear on a particular date, on that day I appeared. The Deputy Commissioner was absent.
You file a written statement.
I filed written
What
statement.
is the procedure? Don't you need to take a disqualification proceedings?
The proceeding was their lawsuit. The complaint was lodged before the member secretary.
Yes.
As per the section 6, it was forwarded to the lawsuit deputy commissioner.
Yes.
And deputy commissioner lawsuit given the opportunity to the petitioner to file an objection lawsuit. Accordingly, it was filed and it was considered loss. And on the page lordship,
That is the procedure. I don't think so.
lordship,
Why not, why they are not allowed to adduce evidence?
lordship,
It is a disqualification.
whether
disqualification
lordship,
proceedings.
whether that's required or not lordship, kindly see the lordship. On the page lordship, that is admitted lordship. Because lordship, the petitioner who was earlier, he was a lordship from the INC lordship. He, along with the other BJP members lordship, acting as a BJP lordship Jila Parishad member, lodged complaint against the lordship ZPC, the sitting BJP ZPC.
Why you are, just wait, why you are referring to this provision? Is there any violation of the provision?
Yes, Your Lordship.
What is the violation? Which
Your
provision?
Lordship, the last part, the operating part of the impugn order, Your Honor, 32A, the last, the true typed copy, Your Honor.
Yes,
It says, Your Honor, I'm just reading out, it's very short, Your Honor. Hence, based on the above two facts, I'm satisfied that the actions of Mrs. Viram Mate are covered by the provisions of Section 3 of the Arunachal Pradesh Local Authorities Prohibition of Defects and Amendment Act of 2006, Your Honor. Here, the Deputy Commissioner had referred to the provisions of Section 3, Your Honor. Now, Your Lordship, Section 3, it is very relevant to refer to the language used under Section 3, Your Honor. Section 3 has got two subsections, Your Honor. Subsection 1 and subsection 2, Your Honor. Subsection 1 refers to the political party, Your Honor, and subsection 2 refers to the person who is otherwise belonging to the member of a political party. Now,
what is your written statement?
Your Honor, although I have
Written
yes,
reply.
Your Honor, written statement, I have annexed it.
Page 51.
51.
Yes, Your Honor.
Yes.
Although this was very reluctantly and very hesitatingly, we have been asked to submit this on the table of the Deputy Commissioner on the date of hearing, Your Honor. No opportunity of hearing was given to us, although we submitted this, but then this was submitted and the receipt of this was acknowledged in the office of the Deputy Commissioner, not by the Deputy Commissioner himself, of course, Your Honor. And while making the written submissions, Your Honor, we have made categorical submissions saying that all the allegations are baseless against me. Now, it runs into, my written statement runs into 13 pages, Your Honor.
Was there any disqualification, no confidence motion?
No, Your Honor, motion has not been
The
initiated.
motion lawsuit, it was moved
Ah.
against the sitting BJP ZPC
Hmm.
by the petitioner along with few lawsuit sitting BJP ZPC lawsuit. Sorry, ZFM lawsuit,
Hmm.
ZPM lawsuit. And he joined lawsuit BJP. He was from INC lawsuit. He joined BJP and then moved along with 2-3 BJP members lawsuit. They moved lawsuit, no
Against
conflict.
the
Sitting BJP ZPC lawsuit,
chairperson.
chairperson lawsuit. And if lawsuit say the page lawsuit page 74 lawsuit. This is a lawsuit no confident motion moved by 7 members lawsuit. Among them lawsuit, it was headed by lawsuit the present petitioner
Yes.
who was from INC, but after joining the BJP lawsuit, he acted as a lawsuit Jila Parishad member of BJP lawsuit. And all these facts has not been denied lawsuit. Here the question is that lawsuit, though the lawsuit, the detailed procedure is
After
not,
the no confidence motion, when was you became the ZPC?
No, Your Lordship, this no confidence motion application has never been acted upon by the Deputy Commissioner, for which it has never been considered. But then the Deputy Commissioner.
But are you admitting that you have joined the?
No, Your Honor,
BJP?
I'm not admitting. Flatly, I have denied to the allegations which has been made against me. This is a very blanket allegation having been made against me while relying upon some photographs and videographs. Your Honor. That has been categorically denied in my written statement. But that,
Where you have said,
yes, Your Honor.
where you have denied. So as the denial.
denial is just a sweeping statement also. No particular denial is there. Clearly denied.
But no proper opportunity.
Lawsuit,
No opportunity has not been given, Your Honor.
kindly come to page 9 then lawsuit. Page 9 lawsuit.
Hmm.
Page 9 lawsuit, the clause 3,
Page 9 of what?
the writ petition lawsuit.
Hmm.
This is part of para 3, clause 3 lawsuit. Sub para 3 lawsuit.
Hmm.
That thereafter, after he has been elected as a lawsuit Jila Parishad member from INC, thereafter the petitioner has been performing her duties and functions strictly as per the relevant rules and guidelines. In as much the petitioner has been maintaining all the discipline, dedication towards her duties and obligations within the ambit and frame of Constitution and rules of Bharatiya Janata Party lawsuit. It's her own statement lawsuit. He has been lawsuit allegiance towards the lawsuit BJP, though she is from
No,
the
Your Lordship,
INC lawsuit.
that must be an inadvertent mistake, Your Honor. However, there is a specific averment in my application saying that
This
I've
is a
been,
statement on oath lawsuit.
this may be an inadvertent mistake. I do.
You wanted to do that, right, the Indian National Congress.
Yes, Your Lordship. This is of course inadvertent mistake. Your Honor. That may kindly be taken leniently, Your Honor. Because in my first paragraph of my application, I have very specifically, categorically said that I have been elected from the INC party.
And lawsuit, if lawsuit come to
That is an
page 11 again lawsuit.
Is it your case that you have merged
No, Your Lordship.
by having a two-third?
No, Your Lordship.
You are saying that you are denying that you have not merged.
No, Your Honor.
You have not joined.
No, I have not. Your
And
Lordship,
what about this page 9? It's very clear.
page 9, Your Lordship, that is page 9, para 3, Your Honor. Second paragraph from the top. Para 3.
Yes.
Of course,
What is this annexure 4A certificate?
yeah, annexure 4A is the certificate, Your Honor.
Where it is page?
This page number,
She has continued consider working Boolean.
page number 36B, you know.
Yes,
Yes.
statement is different, but certificate is.
No,
is right.
certificate is about the losses certification given by the returning.
No, he's basing on this certificate only. And it has been annexed.
Losses statement is specifically losses. BJP, Bharatiya Janata Party, that cannot be a mistake.
We
losses.
understand he's inclined. His heart and soul are with the BJP
Yes,
now.
That is,
But then on paper, he's INC.
no, that is an inadvertent, Your Honor. That may kindly
It
be,
cannot be
Withdraw
even,
and file a fresh.
even it cannot be a cut and paste.
We just cannot.
error losses.
may I be given the liberty to make an affidavit in this regard, Your Honor? File an affidavit with regard to this particular paragraph. So that was an inadvertent, Your Honor.
Will it be permissible?
Losses amendment is the best option after it has been withdrawn losses. Because it has been given
Either
on
you
oath.
withdraw, file a fresh or file an amended petition.
I'll
For
file-
that, you will have to file an amendment, application for amendment.
Yes, Your Honor.
Better you withdraw and file a fresh.
All right, Your Lordship. We'll do it.
Otherwise, this will be a problem for him. But
Obviously,
the fact
obviously.
remains that he has relied the certificate issued by INC.
That
certificate
is subsequent to the complaint.
Forget about the complaint. So far as the statement at page 9 is concerned, he has they made the statement on the basis of the certificate issued by which has been annexed. This is issued by the Indian National Congress. But then prima facie, you have not given effective opportunity.
Losses,
Will stay.
losses here losses summary proceeding losses. Because that procedure is not laid down
No, in
losses.
summary proceeding also, you need to have some effective
No,
opportunity. is
opportunity
given.
losses written.
Notice and accepting the reply and take a decision is not enough.
Basically losses in the normal procedure also under CPC or and all losses. When the issue is losses disputed, then losses trial goes on losses, goes forth. Otherwise losses if it's admitted on recourse losses, then losses no need to go for.
Summary doesn't proceeding doesn't mean that you will take have kind of discretion.
Losses this reply the no confident motion losses. It was moved and it has not been categorically denied in his
Anyway,
reply.
heard Mr. Manto.
Yes,
uh,
Your Lordship.
CW Manto, learned counsel for the petitioner. No, Mr. CW Manto, learned counsel for the petitioner. Press for withdrawal of the present petition with a liberty to file a fresh.
Yes, Your Lordship.
Mr. Swens, Estafin Lerner, senior government advocate. And Mr.
For respondent numbers 3 to 5.
appears for the respondents. Praise the Lord.
Obliged, Your Lordship.
Accordingly, this petition stands closed on withdrawal with the liberty. As read.
Obliged, Your Lordship.
Give it, you just chairs. In that case, you have to file a fresh caveat.
My lord, this is
This is what?
for the disposal of the representation submitted by the petitioner, non-disposal of the representation submitted by the petitioner.
See, again, Mr. Nebo,
Yes, my lord.
there are some procedure. Rules and regulations are there. Addition, deletion, and everything.
Yes, my lord.
That it is done in a certain stage.
Yes,
Just
yes.
because you have detected or allegation of what do you call it?
Double enrollment,
Double enrollment, all this thing.
the enrollment of the debt
The
already
election commission
non-existent.
cannot do like this. I mean, they just cannot, just somebody files and complain, it cannot be acted like that. There's certain rules and regulations for them in certain stage.
No, definitely, my lord, this is the procedures to recorrect, delete, this
That's what I'm
procedure is
saying.
here.
Suppose
But,
today is the election.
In spite of being so,
If you think that this is something, there's a double voter and all those things, there are so many procedures to be followed for deletion, addition, and
yes,
all
my lord,
in
it is there, it is
certain
there.
stage.
Yes, my lord.
You just it cannot be just done like that. If somebody makes in complaints, they'll do it in an appropriate stage.
My lord, since from the month of January, it has been complaint has been made because it was being.
And very stage,
no.
how can stay the counting of the election?
But at least the petitioner has the right to know how the negligence or the erroneous that has
In
been
that
committed.
case, you first approach the election commissioner by filing an election commission. Apply for ask and ask for a procedure in this regard. Then you think about, you examine it and you come back.
My lord, that is why I have accordingly submitted.
This
petition.
appears to be again something.
My lord, it is the counting process.
Stay the
has-
counting of the above mentioned
It
president
is
having double.
nearly 3
enrollment
weeks is
students. How
there.
can
So
we
within
take-
1 week or 3 days, if they can justify that this has been wrongfully made or rightly made, then that is only small matter issues is there. If they are correct, then no matter. And if it is not corrected and double voter is illegal, it's known to everyone. Or voting of a non-existing, which is who are already dead, and we having fake IDs, example, who cannot vote, and they are of a minor, all this, if they are allowed to vote, that the very system of democracy or adult franchise is affected. That is why, and
Who
not
are
o-
you?
I'm
How you are affected? What is
no,
the,
I am
what
I am
right has
one
been-
of the voter of that particular constituency.
what right of yours
My
has
partic-
been violated?
My lord, this is very honestly, my particular right has been not violated.
Then, in that
Ma-
case,
So, but I have being a citizen of India, I have made a complaint that to look the matter, which is been already detected as some negligence or defects. So that has been not considered. That is the issues. Honestly, my personal right has been not violated. To be
Then-
very honest.
then
But
that's why I'm
being
asking.
any complaint of any irregularity, it is a duty of a citizen to complain, and it's also the duty of the authority to comply if it is required in the interest of justice or the interest of the society at large.
Are you a Robin Hood?
Robin Hood was different thing, but this is my lord, don't we have any right to raise objection?
Are
if
you a
any-
candidate?
I'm not a candidate.
Who are you?
Just I'm a normal voter
Then
of that particular constituency.
what right has been violated?
My personal right has been honestly not.
If not, take rest at home. Don't trouble yourself. Heard, mister. You just obtain instruction. What happened to those representation? Well, not issue a notice also. Heard, Mr. MD, learned counsel for the petition.
No, instruction also is sufficient if
You
it
just
comes
take
in the manner.
obtain
As your lordship has rightly pointed out, there is a certain
Considering
provisions,
the
Your Lordship.
nature of the grievance raised in this writ petition, no, the nature of the grievance raised by the petitioner, doesn't warrant any issuance of notice. Mr. However, the learned council, learned standing council for
Lordship,
election commission,
For respondent number 1,
respondent number 1, MS N. Anju, is directed to obtain instruction with regard to the representation filed by the petitioner. You just take, obtain instruction, what had happened.
representation was submitted before.
My lord,
the-
my lord, within a specific time period, within week, that
After 8 weeks,
my lord, my lord, if instruction comes before the counting, that is far better.
Absolutely.
One week is sufficient, my lord, for the
Absolutely.
instruction. I'm not going to raise any strict objection, just instruction if they have complied, whatever may be, whatever comes from the
But the
end of the
representative is
authority.
DO is the party.
DO is also
Are
party,
you
your
not
lordship.
representing
No,
the DO?
representation.
You
is-
are.
Yes, your lordship.
Then you take it from there, whatever is there.
Mm.
After 4 weeks.
My lord, 1 week is,
Otherwise, I'll dismiss it again. I don't want you to go back again today with heavy heart.
just like yesterday.
Of like-
But if it could be made in 1 week, that was what I wish. But then, if my lord insists, then I have no word to say.
You are not coming to the court. Somebody is behind you. Somebody is pushing you.
No, my lord. Just on the grace
Prima
of
facie.
God.
Anyway,
No,
this
okay,
cannot
obliged.
be the issue to be, I mean, determined and executed, adjudicated in the writ proceedings.
Obliged,
Mind you, Mr. Nebo.
Item number 9.
My lord, here we are yet to receive our instructions.
Yeah.
And
Who is appearing? Are you appearing?
Yes, my lord, I am appearing for the petitioners, my lord. My lord, an affidavit would be required, my lord, from the state.
Mr. P.D. Nair. Heard Mr. P.D. Nair, learned counsel for the petition. Next para, who is for 1?
I'm
Number
for the 1 and 3, my lord.
Okay, Mr. M. Katur, learned DAJ for respondent number 1
And 3.
and 3.
I'm for
Mr. N.
two-
Rattan, learned additional advocate general, the state press for is granted 3 weeks time to file. Often instruction or
no,
file affidavit in opposition. List after 3 weeks.
My lord, may I pray for a date, my lord, if it is not inconvenient?
Yes,
My lord, 24th June, my lord.
24 June.
Yes.
List on 24/06/2020.
My lord, deeply obliged.
May I please, Your Lord?
Yes.
Lordship, in the last occasion, your lordship has issued a notice and call for the CD lordship. And a brief account, lordship, before your lordship perused the CD lordship. What happened in this matter, lordship, the accused person, lordship, who was preparing for the state civil service examination, lordship. In the meantime, lordship, the complainant has posted at Daporijo as a junior engineer PhD in the department of PhD, lordship. And they gradually started to come to know each other, and in the later subsequently, lordship, the complainant, he proposed to marry to the accused person, lordship, concealing the fact that he has already married, lordship.
Yes.
And thereafter, lordship, when the accused person, she came to know that he's already married and he has a son also, lordship, he flatly refused on the face of the complainant, lordship. But on what happened, lordship, on the 6/5/2024, lordship, when the complainant, he was continue pursuing for the marriage proposal to the accused person, lordship, he forcefully came to the rented house of the accused person, lordship, on 6/5/2024, lordship. And later on, when the accused person, she refused to allow him to come inside the room, lordship, he forcefully entered, and there was a fight between the accused person and the complainant, lordship. And the medical report of the complainant is also, accused person is also annexed here in lordship. Where matters?
Let us see what is the judgment.
Lordship, this not printed properly, lordship. Well, can it be taken at 2, lordship? 2 p.m.
In a recent judgment, the same issue has arisen before the Supreme Court. The Supreme Court has clarified the law regarding 439, the access of jurisdiction by the Session Court and the High Court. While in the same petition, the accused person approached the High Court directly, and it was rejected, saying that it is only the magistrate who has the jurisdiction, because magistrate exercises the power under Section 437, the 439 and 439 application to be filed before the High Court.
What is the section there? Offense?
Well, it was a magistrate tribal case. Magistrate tribal case. Here the Supreme Court has come to a finding that the accused has the liberty to approach before the High Court because it's a violation of fundamental right under Article 21. So the High Court.
There must be more than that. If they have to show something that why they are not able to, why they have not approached the magistrate or the trial court.
No, the reason is something different.
What is the
that
reason?
the power given under the CRPC. What your lordship is saying, in the few years before, the High Court issued a notification that the 439 application should be moved before the lower court, then before the High Court. It was modified later on by subsequent judgment passed by our court. And now this stand before the Supreme Court was similar to the facts of the present petitioner's case. Because it was a magistrate tribal case, and here also it is a magistrate tribal case. So the bail application was rejected on the ground that it should have been filed before the magistrate first, not before the High Court. The Supreme Court has come to a finding holding that Article 21, when it is violated, the party can never directly approach the High Court because High Court is excellent jurisdiction under Article 226.
It's not his case. There is the difference. Are you pleading a violation of Article 21?
But a liberty, my lord. Liberty.
Huh?
Liberty.
Personal liberty.
Personal liberty.
No, she has been arrested in accordance with the law, and she has been remanded to police and then judicial custody. Is it not permissible under the provisions of law?
Now,
See, there are cases where there is an involvement of the allegation of violation of the Article 21. Then only in that case we can go. It's not your case, it's your regular bail. That the custodial interrogation, there is no requirement of custodial interrogation, right? You have not pleaded any violation of Article 21.
why?
Just because if Article 21 doesn't say that your liberty cannot be curtailed without due process of law. It is a due process of law,
Yes, Lordship.
is not it?
Lordship. Now it's
Your ground for bail is something different.
ultimately, Lordship, it has a discretion with the Lordship only with the ground of bail or not, whether I'll be
No,
tempered with
but
the,
jurisdiction, when you will have to have that thing, when the concurrent jurisdiction, to exercise it, there must be something.
if this application filed with your Lordship under section 437, Lordship,
Hmm.
then this, to my humble understanding, Lordship, then this question.
Are you alleging violation of Article 21? No.
Since the investigation part is complete, Lordship, the liberty, my liberty is being curtailed by the order.
Lordship,
That's it.
investigation part is
Are
not
you
complete.
saying that they cannot arrest you?
Nah,
The court cannot remand it.
no, Lordship, they can arrest me, Lordship. They can arrest.
Pass a remand order?
No, they can, Lordship. They can, Lordship. Now, my only humble prayer is there, Lordship, since I have invoked section 439, Lordship.
Hmm.
So in that case, Lordship can consider the bail application also, Lordship, on the basis of merit, Lordship, whether my custodial interrogation is required at this stage.
That is the reason where Supreme Court has that you cannot directly approach, you can directly approach the High Court when there is an allegation of violation of Article 21. There is no, Article 21 says without due process of law. Arrest, remand and everything, it's due process of law. Think over it. We'll fix it on Monday. If you don't want to withdraw, approach it. All right.
Lordship, in that case, then I'll be liberty to withdraw the matter, Lordship.
Choice is yours.
Lordship. I'll approach the trial court then, Lordship. I'll approach the trial court, Lordship.
No, if you want to want to have another chance to, argue the matter about the maintainability, then we'll give you a chance.
Lordship. In that case, Lordship, I'll try my best to impress your Lordship on Monday then, Lordship. Or let it be on tomorrow then, Lordship.
Tomorrow it will be dismissed.
Monday, Lordship. Lordship. Deeply obliged.
Mr. See, learned counsel for the petition. What you had? Which? Are you a party in this bail application?
No, Lord.
What do you want to assist? What do you say on this?
Fixed for a Monday, otherwise, my lord, I have something to submit, but since now the court is not on the.
No, you being an officer of the court, since you are assisting, you assist the court
My-
also. What do you say?
Otherwise, my lord, my.
They are saying that Supreme Court says there's no bar to directly approach this court.
My lord. So far, this point is concerned, my lord, that if it is true that the Supreme Court say, my lord, this can be, both, this is the parallel power that both the court can apply. So far, this point is concerned. But so far, the main is concerned, my lord, I am here for objecting the bail. The bail should not be granted on a certain ground, my lord. But I will not, since the matter is already fixed for Monday, so my lord, my submission on the merit of this case today will be, my lord, futile exercise, my lord. So since the matter is already fixed.
No, I
on
just
Mon-
wanted to know, what is your view?
My lord, so far my view in the particular point is concerned, my lord, that yes, so far, my lord, sometime, my lord, we have faced many situations that we come to the High Court also directly, since the 439 is
So
both.
neither here nor there. Sir, what do you say?
The advocate of the Supreme Court says, if there is a question of personal liberty and the petitioner is alleging violation of Article 21, and in a bail application, when a prayer is being made for bail, he is naturally saying that if the bail is not granted, his personal liberty will be affected. So 21 will come in mind. So and the Honorable Supreme Court has made it clear that there is no difficulty in approaching the Honorable High Court directly. So in that way, my
I
submission.
don't know, subject to, which is binding on us, but then we just can presume that he has, if a bail is approached, we just cannot have a presumption that,
No.
I think my
In-
view,
in
that
his
there is a
sub-
violation of.
Subject to what he has said in the petition, if he says that his personal liberty is affected in his.
Because it's not case of illegal arrest, that all those cases like Arnab Goswami, the allegation of illegal arrest and all other things,
No,
and the
I-
bail, including bail,
Yes.
which
Well, as far
involves
as-
their personal liberty.
Yes, well, as far as the law is clear, law is concerned, it is clear. But if in the petition he doesn't allege violation of Article 21, then the question will be different.
Because basically, we are also on the presumption that since on the basis, on the merit only, since she's a lady and since there may not be a further custodial interrogation.
Yes.
That was what I wanted to consider on the basis of this.
Okay.
But then,
But so far as my maintainability petition is concerned, I know there's one paragraph 9, may I read this? Unfortunately, the term custody, detention or arrest have not been defined in the CRPC, and when we must resort to few dictionaries to appreciate their contours and order and legal practice. The Oxford Dictionary online defines custody as imprisonment, detention, confinement, incarceration, internment, captivity, remand, duress, and durance. The Cambridge Dictionary online explains custody as the date of being kept in prison, especially while waiting to go to court for trial. Longman Dictionary online defines custody as when someone is kept in the prison until they go to court, because the police think they have committed a crime. Chambers Dictionary online clarifies that custody is the condition of being held by the police, arrest or imprisonment to take someone into custody to arrest them. Chambers Thesaurus supplies several synonyms such as detention, confinement, imprisonment, captivity, arrest, formal incarceration. The Collins Cobold English Dictionary for Advanced Learners states in terms of someone who is in custody or has taken into custody or has been arrested and is being kept in the prison until they get tried in a court, or if someone is being held in a particular type of custody, they are being kept in a place that is similar to a prison. This now this is about custody. A perusal of the dictionaries thus discloses that concept that is created is the controlling of a person's liberty in the course of a criminal investigation or curtailing in a substantial or significant manner a person's freedom of action. Our attention has been drawn in the course of rejoinder arguments to judgment of full bench of the High Court of Madras in so-and-so, as also to the decision of the court in Director of Enforcement versus Deepak Mahajan, 94-3 SCC 440. In view of the composition of both benches, reference to the former is osseous. Had we been called upon to produce Deepak Mahajan earlier, we may not have considered it necessary to undertake a study of several dictionaries, since it is a convenient and comprehensive compendium on the meaning of the arrest, detention, and custody. I'll just read another paragraph.
Fix the matter tomorrow. Okay, man, I will fix the matter tomorrow. I'll decide.
If necessary, I will also advise the court, no difficult. If your lordship desires,
Only
otherwise.
prayer of the learned counsel for the learned counsel Mr. T. Garam, learned counsel for petitioner. List this matter tomorrow. 17/05/20. The additional PP is to retain the CD. We'll see tomorrow. We'll decide.
If your lordship desires my presence, I can come.
If you are there, you are most welcome. And also, you place this.
The judgment.
Judgment. You also, what of you also go for the judgment?
No, sir.
Deeply obliged, Lordship.
I clarified properly. Earlier, I was not known the sector. There are two types of bail petition. One is 436, where there is a bailable offense.
Yes.
Then non-bailable offense, but tribal one is 437. Then a section where the exclusively tribal by session, in the case 439 is attractive. So here in the case, 439 is not attractive. Even if it is trial rejected, then he can approach the High Court by invoking 439, by taking that, by showing the rejection order. This is the procedure.
Yes. I am also of that view. But then they said there's a, I mean, I have not come across. I will decide tomorrow. You may also assist the court, learned senior counsel. Please come tomorrow, assist the court, both of you.
In that case, no, I was not known the section. No? I just had only 439, but I do know the section.
Yes, Lordship, matter may be released after 3 weeks. Matter may be released after 3 weeks. Lordship, substantial question of law was to be determined today. Yes, for the petitioner.
Lordship, interim order is there. Highly obliged.
Item number 12.
Please, your lordship. Lordship, I'm sorry to that I couldn't personally present before this honorable court. My lord, matter pertains to transfer in the subordinate court staff, basically. So from
Yes. Why has it been listed for orders today?
already affidavit has been filed by the respondent on the last
So listed
occasion.
for admission hearing.
My lord,
All
may,
right.
my lord may dispose it of today itself. It's
What
a
is the matter? Why it should be disposed of order stage? Why?
It's a small issue, my lord, regarding
What is the issue?
regarding the transfer in a subordinate court staff, my lord.
Yes, I cannot take up this matter. Somebody has. You are for?
I'm for a respondent. I'm representing 127. I'm standing counsel of the Guwahati High Court.
Sir, I cannot take up this matter. List this matter before any other appropriate bench without me. Huh? It's a transfer from
CGM come civil judge Changlang to JMFC, from JMFC come civil judge Pangin, my lord.
Okay.
Yeah, seeking transfer from Sanglang to Chiang district. Now, there is no such provision that inter-district transfer. Transfer can only be done within the jurisdiction of the district session judge.
I cannot take up this matter before any other appropriate bench.
My lord. Much obliged, my lord.
Item number 13.
May it please your lordships. May it please your lordships. This is a petition under section 11 of the Arbitration and Conciliation Act, my lords. I have invoked arbitration and I have appointed my arbitrator, but the respondent has failed to appoint their arbitrator. Hence, I have filed this petition seeking that your lordships may be pleased to appoint an arbitrator on behalf of the respondent, my lords.
Yes.
Notice has been issued in the matter.
Yes.
Coming after notice, my lords.
No, we cannot resist. Sir, you have not taken steps.
Yes, ma'am. We have not received any extra copies till date.
I have taken steps.
Lordship, today morning we have sent the copy, extra copy to the government as well as to the power department, standing counsel.
No, this office note of 15/5/2024 says no steps has been taken. Is there any private respondent?
No, my lord.
Then what sort of steps we are saying? You are appearing for all the
No,
respondents?
I'm appearing for 1 and 2, my lord. There's standing counsel
okay.
for power, my lord. There's standing counsel for power, my lord.
They're the only
Elder-
respondents, my lord.
Have you taken steps for this respondent number?
The power department also we have served the copy, extra copy.
Lordship, I'm appearing on behalf of El Parme.
Yes, what is your stand?
We have received our extra copy. So
It's an appointment of arbitrator. What extra copies you are talking about?
I'm
we
so
have to take
obliged, my
instruction,
lord.
my lord.
I'm
because-
so obliged.
What is your stand?
Lordship, we have to take instruction. Today only we have received instruction.
See, there is a judgment of the Supreme Court. That's a petition has to be disposed within the time frame by the High Court.
Next week, my lord.
Well, list it next week, let them obtain instruction.
Very well, my lords. I'm obliged.
Heard, Mr.
Manu Seshadri, my lord.
Learned counsel for the petitioner. Mr. The learned counsel for the petitioner has submitted that steps have been taken by providing the extra, providing extra copies to the learned counsel for the respondents. Mr. This morning. This morning, yes?
Yes, Lordship.
No, before that, office note dated 15/05/2024 reflects that no steps have been taken by the respondents for service of notice upon respondent number 3. You are appearing for 3 also?
Yes, for respondent.
However, however, the London Council petitioner has submitted that second step so and so this morning. Mr. MS T. Wang, London State Council for respondent number 1.
1 and 2, my lord.
1 and 2, and Mr. S. Rang for respondent number
3.
3.
Yes, Lordship, on behalf of El Perme for Power
They
Department.
have submitted that they have received the extra copies. Mr. And they have sought for some time to, they have prayed for some time to obtain instruction. Considering that the present application next vera is for a direction is for appointment of arbitrator. Under section 11 within bracket 6 of the Arbitration and Conciliation Act 1996. The Landed Council, the respondents are directed to obtain instructions within 1 week. List this matter after a week. Yes, on next date we may dispose it of. After a week.
Would your lordship consider listing it on the 27th, my lord, subject to your lordship's convenience?
27/05/20.
Yes.
It's better.
I'm grateful, my lords.
You go through the judgment. It has to be within the time frame. You cannot afford to take time. Unlike in other cases.
Grateful, my lords.
What is this?
My lord, this writ petition was filed against an order of
You file a review in that case.
Now, this IA I filed for a different purpose, my lord.
IA is for stay of those notices.
My lord, what has happened on the
Why
last-
you have not made
No,
mention?
my lord, on the last occasion, the interim prayer was not refused. What happened, my lord? It was taken online, number 1. 1 o'clock, the court was about to rise. And hurriedly, as soon as I got the petition, the matter was called up. So because of that, my lord, otherwise, my lord, on merit, it's very simple. During the pendency of one proceeding, another notice has been issued. Appeal is pending. Appeal against the final order passed by the estate officer is pending. And
Is there any private respondent?
No.
Otherwise, also, if you have been allowed to construct
My lord,
the boundary wall,
my lord.
Is
Boundary
it
wall, I
not-
have been able to construct, but then my petitioner is apprehending that.
they want to evict you.
Yes.
And the court has directed directed you to continue. allow you to
Only the
continue
boundary wall. So
construction.
that way is correct, my lord. So lordship will give some protection, at least status quo will help. Till the
No,
matter.
you have been allowed to construct the boundary wall. But
No.
the question of eviction.
I am allowed to construct only the retaining wall. About the main building, my lord, there is no order. I have also not prayed for any order. I am only praying that eviction should not take place in the meeting. In fact, my lord, my learned friend, appearing for the other side on that day, admitted, and it is recorded in the order, that if the original proceeding is pending, fresh notice will be without jurisdiction. So that way it was quite clear on that day. Only thing that, my lord, hurriedly it was, the interim order was prayed for, and I forgot actually, to be very frank, my lord, to pray for the interim order of the stay of the interim order, my lord. So I only pray that status quo will help, my lords.
Anyway, indirectly, you want that this has to be modified.
No, my lord, I'm praying for something more than what was there. Yes. I'm not praying for any modification.
What do you say?
Page 30, the IA lordship. Here, lordship, the subject is damage of road and road shoulder by earth cutting along the road, lordship.
Page
Because of this-
IA.
Yes, in the
Page-
IA. The notice they are talking about is lordship. No,
Page-
not in IA, in the main lordship.
Hmm.
This, which has been, the notice has been given on,
But then this court has allow
522.
him to construct the retaining wall. Is not it?
Lordship,
Retaining wall or wall?
Yes, retaining wall.
maybe if the construction is, construction is allowed, Lordship, then.
No, no, I'm
maybe the
not-
Petitioner will
I'm
get
not-
the bill. It comes. Payment, Lordship, according to that. But then Lordship can see the construction here. They have just started the main building construction. If this construction is allowed, then.
No, 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 main building construction, I have made it very
Retaining
specific.
wall, retaining wall.
Retaining wall only. I prayed for that only, so that entire relief cannot be granted by an interim relief.
In the picture, but then Lordship, in the photograph, Lordship, this is the.
Yes, sir,
Retaining
you have appeared on that day.
Retaining is something else.
Yesterday, I appeared because as all the government advocates are missing from the court, so I was present.
You said on this basis you will stay. He may be correct. When the appeal is pending,
My
Yes,
mind,
madam.
my
according to
learned
him,
was quite
prima facie, it's not
responsible in saying
tenable.
that.
Notices are not tenable.
Correct.
We'll just say, in that case, we'll say status quo.
No, no, that will.
It's because
All right.
after the construction of the building, Lordship, after the construction, they say the building has been constructed, all the money.
No,
has
we'll
been-
not say about the building and
No,
all.
no, no,
We'll say
building I'm
the
not-
court has directed to continue construction of retaining wall.
Lordship.
We will just say to maintain status quo.
My lord.
All right.
Status quo, agent to that.
But then I doubt this, it will amount to modification of the interim order.
No, no, absolutely
Yes,
not.
Lordship.
Absolutely not, man. It is.
Maybe
there
just
is-
just because IA has been filed.
Yes.
We'll dispose of the file, the IA.
Yes, yes.
Or Mr. D. Mojumdar, London Senior Counsel, assisted by Mr. London Counsel for the applicant petitioner, and also had MSG at the London Additional Senior Government Advocate for the
Status quo.
state respondents. Next para. Filing this application, the applicant petitioner has sought for suspension of the notices so and so, at page 5 of this paragraph, issued by the respondent number 320, which is annexed in the connected with petition number 188 of 2004. It is the contestant of the senior counsel to the applicant that this court, when was this order?
Day before yesterday, man.
On 13/05/2024.
13/5.
Was an interim order. To allow the petitioner directed.
So it was actually, prayer was made to allow him.
Lordship. Lordship, may
Allow the petitioner to continue with the construction of the retaining wall only to prevent the structure from collapsing,
Yes.
comma. Inadvertently, the interim period of suspension of notices, though were read, could not be considered. Mr. He submits that unless the impute notices are suspended, the respondent authority may implement the impute notices by evicting the petitioner.
which will deprive his right as well as the petitioner, the writ petition would be rendered infructuous. Mr. Is it your case?
My lord,
That
yes.
if
Absolutely.
if it is
Yes.
implemented, therefore he prays for suspension of the impugn orders as referred to above. Mr. What is your submission?
Lordship.
MSG at the London Additional Senior Government submits that while the entire matter was considered by this court on 13/05/2024. No, well, not while. After considering this, after considering all the, considering the entire matter, this court had passed the interim order on 13/05/2024, directing the petitioner to continue the construction of retaining wall to avoid collapsing. What collapsing?
Lordship, I don't
To
know.
avoid collapse of the structure on the land.
Road, Lordship. is,
And
main road.
there's no, the prayer for staying the operation of the impugn notices, in essence, have been deemed to have been rejected. Mr. Next paragraph. Considering, having considered the submissions of learned counsel of the parties and considering the facts and circumstances in the present case, it is in the interim, it is provided that the parties to maintain the status quo as on today. That's all.
Lordship.
That will be in the middle, my lord.
In between,
In between.
the IA is then disposed of.
Deep lord.
Other one? Will be the latest one. No, this is 2015. Get the latest one. Huh? They asked you guys to provide. Get it done. Yes,
My lord, this is a tender matter, my lord, where the work has been awarded, my lord, in violation of the tender guidelines, my lord. In fact, because it was a single tender, my lord. Out of the 6, my lord, 5 were rejected as non-responsive, my lord. And only one firm was found to be technically responsive. But the PMGSY guidelines says single tender means in a situation where there is only one technically responsive firm, it would also amount to a single bid, and such single bids should not be opened, and subsequent tenders should be called.
yes, this is listed for what?
Today
You have
this is-
taken steps. That's it.
Yes, in fact, on last.
We'll list it for next week. You have taken steps on when?
Yes, I had taken steps, in fact, taken steps on 12/3 and on 29/4.
12/3.
Yes, 29/4, my lord, it was still awaited. So that liberty was given to take steps by Dusty as well.
Yes, you have filed
Now,
the affidavit.
yes, so I filed an affidavit saying that I had this private respondent is personally known to me. I had called him up and sent it through the WhatsApp also, that notice. And he said that he requested it to be sent to DTDC, since the respondent is from Dibrugarh, ma'am. So I've taken that also, ma'am. Now the record also shows that it has been delivered, ma'am. Delivered, yes.
Okay.
And otherwise also I have personally informed
Okay,
also.
then next we will fix for admission hearing. This is for admission hearing.
Otherwise,
And Mr. This okay, learned counsel for the petitioner. And also heard Mr.
On behalf of G. Tarak, Lordship.
Just my.
T. Garab, learned counsel appearing on behalf of on behalf of G. Tarak, understanding counsel to the Rural Works Department.
Why you are not filing any affidavit?
Lots of this, in fact, I have been instructed by Mr. G. Tarak that this matter may be taken up tomorrow, Lordship, because he is out of station.
No, there is a order that on the appearance only your.
Yes,
case
my
will
lord,
be
on the
continued.
appearance, but
Next week, we'll wait for some time.
Lord,
Let him.
because my lord, neither the department is filing the affidavit and the respondent of the affidavit, my lord.
The learned counsel for the petitioner has filed an affidavit to the effect that the respondent number has been served. Notice upon the respondent number to Dusty Mott has been duly served. Here is the affidavit and the where do we get it? That it has been received.
Delivered, my lord, it is,
Delivered.
my lord, this page 5 is the DTDC, my lord, number, and 6 and 7 is my WhatsApp message, my lord. I sent it to the Rohit More is the director of the ATW, my lord, who is the respondent number 6, my lord.
It
This
is-
notice, my lord.
It is seen that
And page 8 is
the
status of
notice
the
has been served by
WhatsApp
DT
messenger, my lord.
WhatsApp messenger as well as
And by courier and
subsequently by courier through DTDC.
DTDC, my lord. Page 8 it is the report, my lord.
And the same
Successfully
has been delivered. Mr. Does the service upon respondent number 6 is complete? Is complete. List for admission on next week, after week.
On my lord, Monday, my lord.
Monday. Make it Tuesday so that when it was delivered.
It was 6th of May, my lord.
6th of May. Make it, then Monday.
Tuesday.
20.
Tuesday then.
21.
21.
21/05/2020.
All right.
Publish.
Yes. Where?
I'm appearing for admin number 17. Madam.
Yes.
18. I'm sorry.
Yes.
Yes, due to non-existence of state consumer dispute redressal forum at Arunachal Pradesh, I am not able to file any appeal before the court. That's why I am filing this application before the Honorable Guwahati High Court. Lord.
Yes, what happened?
Lordship.
No consumer forum.
Lordship, we have filed in the similar matter, we have filed affidavit saying that, Lordship, the file has been reprocessed, which was reprocessed, Lordship, has been put on hold.
Due to MCC.
With regard to, yes, Lordship, Supreme Court judgment on 3rd March 2023, Lordship. So,
Supreme Court judgment.
yes, Lordship.
Saying what?
Lordship, in item number 18, Lordship.
18.
18, Lordship. Ghost Brothers, we have filed, Lordship. Lordship may come to page number 6.
You have not filed affidavit?
We
Have you
Lordship.
filed?
Yes, Lordship. In Ghost Brothers, in item 18, Lordship, we have filed.
Ghost Brothers.
Yes.
This office note reflects something else. Affidavit is not yet filed. On behalf of, okay, respondent, who is respondent number 3?
Lordship, most probably.
Okay, okay. Service completed?
Yes, Lordship.
Huh? Yes, your affidavit says what?
Lordship.
Page?
6, Lordship. Just a second. Lordship.
Page 6 is your affidavit. Ought.
Oh, Lordship, 3, 4, Lordship, 4.
Page
Para-
4.
Para 3, para 4 and 5, Lordship. Page 4.
Respondent number 2. Affidavit on behalf of respondent number 2.
Lordship.
Is it? Affidavit
Yes,
filed by
yes.
the respondent number 2.
Yes, Lordship.
Yes, then para?
Para 4 and 5, Lordship.
Para 4. Roman
Para
4.
Roman 4, Lordship.
Yes.
Roman 4 and 5, Lordship. Here, Lordship, after departmental screening committee disqualification, Lordship. This is the status, Lordship. At para 6, we have said that the department is now in the process of meeting up the formalities, Lordship, to amend the rule and continue the appointment of president, State Commission, as per the directives of SCI. Lordship.
Where is that Supreme Court order?
Order, Lordship, is in Annexure 2, Lordship.
Hmm.
Page 11,
Where is the relevant one?
relevant, Lordship.
Then in that case, there's direction for appointment preceded by written examination.
Yes, Lordship.
It will take time. You will have to wait for that. What to do? When can you complete the process?
Lordship, they have said the process is on, Lordship, but then the latest status, Lordship, I can't say. And in this,
On next date, we'll fix after 3 weeks, right?
In the meantime, Lordship, interim may be allowed to me to stay the proceeding because in WPC
Which
number,
one?
in item number 18, in WPC number 326, 2023, there will be interim for non-existing of state consumer from here at Arunachal Pradesh, Lordship.
interim is there in the Ghosh Brothers, Lordship.
Interim order is there.
Yes.
Interim is here in the WPC, Lordship. Already interim has been passed.
You want that it should be continued?
No, it is not my Lordship.
This is new case.
This is new Lordship.
Item number 17, this is.
My item number 70, WPC number 123 of 2024. And this is for
This is with regard to Lordship, item number 18. And the petitioner's case is item number 17.
This interim order.
Interim order is item number 18. In item number 18. Similar matter, Lordship.
Similar.
Yes, Lordship. Due to non-existence of
What deficiency you have against whom?
insurance company, Lordship.
Insurance.
Yes, Lordship.
In item 17 also.
I'm
And my friend is speaking.
No, I'm asking what is the deficiency you have claim against?
Item number 17, Lordship.
Yes.
Yes, Lordship, I have a valid insurance,
Ah,
but the claim is not relieved by the petitioner, Lordship.
what about you?
I have so sure.
Damage.
That card was as per the complaint given by the party. There was a defect in the card.
Yes.
The owner, the person who person the card is one thing is new.
So it is be listed together. Heard, Mr.
G. Pukon, Lordship. I'm for waiting for item number
Counsel
17.
for the petitioner in writ petition 123 of 2024 and Mr. T. Tapak counsel for in writ petition 326 of so and so, 2023. It's matter is pending since last July.
Lordship.
Within even after a month, I mean a year, nearly a year, you are not able to complete the process.
I'll take the latest status, Lordship.
Get the lotus state and ensure that it is constituted within 2 months.
Unless a
Will not direct it, but then you appraise the authority. You cannot
We are
allow.
continuously pricing, but then Lordship, unless a direction goes, I don't know. Lordship.
So far as
We'll
well, unless
we'll have to dispose of the matter. In that case, we'll fix the matter after 2 weeks.
2 weeks.
In the meantime, you take appropriate,
Yes.
do obtain instruction on that day, we'll dispose and we'll direct it.
interim.
2 months will be, I mean, enough time. You will have to issue advertisement
Lordship.
and conduct the written examination and all. In item,
This was
item
filed on
17, Or then MSG at the learned addition PP for the state. Now, are you appearing for in respondent number? Respondent number 3. In 17?
No,
There's
Lordship, I have soft copy, Lordship, but not a pen.
You right, respondent 4, respondent in item, the writ petition number 326 of 2023. Considering that this court on what courtship action will be taken to you?
Lordship.
How you are apprehending that any action may be taken against you? Why?
for interim.
For interim, Lordship.
Why?
Because until and unless the appeal may be filed, there is no state commission for
Yes.
Lordship. That's why state order dated passed in impin order dated at 36/2023, Lordship.
36?
36/2023.
What does it mean? 36, 23rd,
30.
30?
6/2023, Lordship.
That is the order of the
District Consumer Registration Firm, Lordship. At page number 55 to 61.
Considering that this court on 17/07/2023 in writ petition 320 WPC 326 of 2023 has passed in a similar matter, has passed an interim order providing not to take coercive action
against the petitioner pursuant to the order dated 19/11/2022 passed by the District Consumer Dispute Redressal Forum, East Siang District. I deem it appropriate to grant the same, provide the same, similar interim order. Mr. Accordingly. Till the next date. And accordingly, it is provided that no coercive action shall be taken against the petitioner. Pursuant to the order dated
2023. Judgment and order dated
23. Passed by the District Consumer Dispute Redressal Forum.
Yes, Lordship.
Which district?
Papumpere, Lordship.
Papumpere District. UPIA.
Yes, Lordship.
UPIA. In which case?
In CDRC -122-23rd.
List after 2 weeks.
Obliged, Lord.
You give the number of your case, that consumer case.
Obliged.
In that case, you will have to write separately, right? And in item so and so, the writ petition 26, interim order to continue separately, but the method. Then last one, first one you said list along with this, list the matter along with WPC so and so, huh? Separate order.
This petition was filed alleging custodial torture in the police custody man. And Lordship, this Honorable Court was pleased to pass an order on the last occasion. And there was a direction to the DGP to submit a report. And also the hospital authority.
Who is respondent number 6 and 7?
Respondent number 6 and 7 are the officer in charge and the inspector of the women police station who were
Yet to be
imputed
served.
by name.
Subversive was awaited.
That is there. But
Mr.
No, report, they have to submit the report today itself. Lordship, kindly have a look at the last order, madam. The DGP has to submit the report today itself. It is respondent number 3. And the hospital authority where he was treated has been directed to submit the status by in seal government. Para 9. Para 9. At this juncture, the respondent number 3 is to submit a report as to why the petitioner has sustained the injuries as depicted by the pictures. Annexure 4, despite the fact that the order dated 6/5/2024 clearly reveals that the petitioner was fit to be taken into custody. A detailed report is to be forwarded by the respondent number 3 DGP PHQ Itanagar Government of Arunachal Pradesh as to what led to the petitioner's present condition. Para 10 also, madam.
Yes.
Lordship, we have to file Lordship, paragraph reply Lordship. Today only we have received this Lordship.
Have you seen the direction order passed by this court on the first day? Where is Mr. Jambe? Where is the PP? Are you appearing for whom? You are appearing for whom? Are you appearing for
State Lordship.
DGP?
I'm for it, Lordship.
Where is Mr. Jambe?
3, 4, 5, Lordship, he was here, Lordship, in the morning, Lordship, but due to some urgent.
Direction is very clear, my lord. I have got a photograph of the present condition of the petitioner in a video. If your lordship desires, my lord, I can just show it to your lordship. My lord. Lordship, photographs I have given, but present condition, my lord, I have got a photograph. Video, my lord. And if they are unable to file the report, the DGP may be directed to appear
Who
personally.
is the petitioner?
Petitioner is one Debia Tara, my lord.
Who is? His working is?
No, he's a district accounts manager. National Health.
Yes. Any report?
Lordship, this,
Manoj, I have received sheet cover.
Well, responded by hospital authority. Well, there is a direction to the hospital authority also to submit a report.
What about DGP?
Lordship, this is the Lordship, status report, Lordship, I have. Status report.
By
of
DGP? Have you seen
No,
the order
Lordship.
of this court?
No, Lordship, that's why, Lordship, from the DJP, Lordship, I have received this paragraph reply,
Paragraph
Lordship.
comment is not asked for. The report is asked for.
Lordship, let the matter fix tomorrow, Lordship. I'll take the instruction, Lordship, further instruction. Maybe it's a paragraph reply here. Okay, no. Okay. Lordship, this is the Lordship, actually, this is, as I stated, that is a para-wise reply, but it is actually inquiry report.
তখন জিনিসটা রাখার কোনো আর কোনো একটা ইন্ডিপেন্ডেন্ট মানুষকে যে কোনো কন্ডিশনটা দেখে কোর্টে দিতে হবে। হ্যাঁ হ্যাঁ and having petitioners assistant. Principal Government Hospital. Principal Hospital. Hospital doctor report doesn't tell you with this. So you can ask for inquiry for and ask her the ask for wait.
This is by whom?
Lordship, from the Lordship,
Trims from
not
Trims
Lordship,
Hospital.
from the Lordship, IPS is, IGP Lordship. Lordship, here Lordship, the inquiry report is para 9 Lordship. They stated the report of the medical board was also produced and perused, and there are mentions of simple bruises on the buttock and back region of the accused, which seems to be a result of assault. Other than that, no injuries found on person of the accused indicative of the alleged assault. Further, the medical report only finds the accused unfit based on his mental condition, given his past history of acute stress. As per the Lordship, this report, a detailed inquiry has been done through an additional superintendent of police rank officer as per the direction of the learned DGP Arunachal Pradesh. The finding of the inquiry report are hereby produced and with necessary supporting documents, Lordship.
The petition. There we have given colored photographs of the nature of injury suffered. I do not know what has come up in the report, what they are saying, and I have got a present video also as to what is his condition, physical condition.
You have tried to flee.
My lord, he was taken into custody from the from Sahumal. No, he was asked to go to Sahumal. He was along with his wife. And wife said that no, I'll take him to whatever, wherever you want. In my car, they said, no, I will take it. So he was taken to custody from near the presence of the wife. So there is no question of fleeing. They are trying to make out a case.
We'll have to determine.
No, my lord, lordship, at this stage, my lord, that I know they will be taking all kinds of plea. At this stage, what is necessary is what kind of injury has been caused to him, to his body, that has to be ascertained. But I do not know what is coming.
There is a report by the medical board.
I do not know whether it is telling you. I am asking your lordship, my lord, whether it is telling with the nature of injuries that is there in the photograph of the lordship.
No, we'll not go by photograph. We'll go by
That's what, my lord.
Opinion of the medical board.
No, but that's why I say, if he doesn't tell you, I have got a video also.
No, it's okay. It's okay. Not today.
What
the report is, it's okay. They say it's a detailed report by the medical on your health.
Yes.
We'll consider that. What is your exact prayer in this petition?
My prayer is to take appropriate action against the police officer who has caused this injury, my lord.
Yes, that we'll have to hear that.
No, my lord, what I am saying is, my lord, at this stage, it is necessary to ascertain the exact position. In the report, what has come, I do not know. We are not privy to that report. If they are hiding everything after 10 days, after 15 days.
Okay. Report this report will ask them to bring on record.
No, my lord.
So far as this
provided. My prayer is slightly different. What I am saying is, my lord, in the report, if they are not coming up with the exact and real position, then there is a necessity of making.
No,
it-
so far we're concerned about the health.
Yes,
So we have the report from the medical.
my lord.
So whatever treatment is to be, required to be done, it is being taken. And there is suggestion either to Tezpur or some Mitfu. There's some suggestion
My lord,
that will be taken
that is
care.
about the future treatment.
Huh.
My prayer before Lordship is whatever injury that has been caused to his person, to his body, whether it has been properly reflected or not, because after 10-15 days, all the injuries will be healed. And he has suffered injury in the kidney also because of kicking.
No, this is by the medical board. We'll
My
have to go by what medical board said. We cannot have your own, there are three persons. One chairman and two other members.
But that is what I'm saying. These persons, whether this report is correct or not, that has to be a certain hour, unless, because my lord, what I'm saying is, my lord, we have got the recent video of the present condition of the petitioner. Your lordship will kindly have a look at this.
Basically, you are having already an hypertension and having a anti-hypertension medication already.
No, my lord, if the condition is not bad, TRIMS hospital itself has asked for referring it to a higher center.
Yes.
Because the condition is beyond their capacity for treatment.
No, it is not reflected, Lordship.
Yes, that
as
is why
no-
I'm saying
no,
it's not
Lordship.
correct. Reports are not correct. Reports are not correct. That is what I'm alleging at this stage, my lord. That is why I want this Honorable Court to just have a look at the photographs in the writ petition. If these documents which they are now showing is not telling me the kind of injury he has already suffered before filing the writ petition and the present condition, my lord, lordship will direct them to have a my lord, independent inquiry by a doctor in the presence of the petitioner's wife. If they are saying that there is no injury at all, and he wanted to flee, all these are false allegations.
Because injury was there,
my
Lordship.
lord-
It's
my-
not Lordship, denied, Lordship, but the medical report, Lordship, he is fit, Lordship. He's only unfit on the basis of his mental condition, which is the past history, Lordship, of the acute stress.
My lord, I'll just pray before lordship, kindly have a look at page 29 of the writ petition. One thing I want to show you to lordship, my lord. Page
It's
28.
okay, we'll consider this is today is for report and
just-
all,
just-
we'll consider on the next
You-
date.
my lord, just one.
Let the authority take care of his health.
My lord, they will take, my lord, just 2-3 lines I want to show from page 28 of the writ petition. My lord, there is a reason, my lord.
28.
Page 28.
Yes.
Just bottom paragraph, my lord. I have perused the application. This is an order passed by the magistrate on 6th of May, magistrate. I have perused the application and arrest memos and medical fitness certificates, etc. of accused person, wherein examining doctor opined that the accused persons are fit to be kept in custody. Absolutely fit, man. Now, after this was of 6th, 7th in the evening, when the attendant goes to visit him in the police custody, he finds that all entire body, my lord. This is not a normal, my lord, torture. It is a third-degree method applied. My lord, lordship may kindly have a look at the photographs. Paragraph page 30 and 31. Just page 30 and 31, lordship may have a look. It is an inhuman torture meted out to the petitioner, my lord. Inhuman. And he was taken initially in the women police station. Thereafter, for the purpose of torture, he was taken to the normal police station. And the kind of torture, lordship may kindly have a look, and I have got a photograph, my lord. Entire body. Man will die. And he has suffered kidney injury.
Because of the torture.
Yes, my lord, he was kicked. This is what I'm saying, my lord. And in the report, they may not come up with all this correct information.
How do we disbelieve the report of
That
the
is why I'm
medical-
saying, my lord,
medical board?
if the petitioner has given a false photographs, then there is a necessity, if the photographs are not telling with the kind of report they have given, then there is a necessity of directing an inquiry in the presence of the petitioner's, my lord, wife and relatives. It is necessary, my lord. Otherwise, tomorrow they will say, no, nothing happened. He fell down.
Lordship, as per the report, Lordship, the accused person has sustained some injuries, including bruises on the buttocks, etc., which is corroborated with the picture shown, Lordship. That is the injury, Lordship. It is not denied, Lordship. But that injury was caused because he was trying to flee custody and force has to be used, Lordship.
Trying to
He
flee.
tried to flee, yes,
First of
Lordship.
all, my lord, the allegation of trying to flee is absolutely false. He was taken in the presence of the wife.
No, Lordship, from their Lordship, they wanted to Lordship, he wanted to Lordship, accused to other PS Lordship, in the between Lordship, he tried to flee, Lordship. It is all it's all in the submitted in the report, Lordship. It is there in the report.
There is multiple bruises marks in the back of thorax,
Yes.
neck. There is.
Yes.
We'll see. Mr. D. Majumdar, learned counsel for the petition. You file this, your report
Lordship.
by affidavit. Bring on, we'll keep the report here.
Lordship.
You bring on, record your report. Assisted by so-and-so, learned counsel for the. Mr. L. Hage, learned additional PP. No, before that, service report in the office note dated 15/05/24 reflects that service reports, award service report in respect of respondent 6 and 7. Next paragraph. Mr. MS L. Hage, learned additional PP, has placed on record the. Is it parawise or report?
Lordship, as per the Lordship, I have received the Lordship, it is a report, Lordship,
Has
actually.
submitted the has placed the
Inquiry report, Lordship. By way of affidavit, they have submitted, Lordship. But if Lordship permit,
on behalf of furnished by the respondent number 3 with the which consists of inquiry report with regard to the allegation in the present case. This stuff. She is directed to file, bring on record the reports within by filing by way of affidavit. Mr. Kitagum, standing counsel for health department. Respondent number 8 has also placed the seal cover. They placed the report of the medical board in a seal cover. You give the,
My submission before lordship will be,
you provide necessary medical treatment, whatever is required. Right? But we'll need to examine the,
my lord,
the measure of prayer. Will
my
have to-
only apprehension, yeah, I'll leave it to your lordship. My only apprehension is the exact condition of the petitioner must come in the report. I am
Yes,
apprehending my
I'll tell you the exact condition.
lord.
Acute stress disorder, acute kidney injury, resolve,
Yes.
hypertension. These are the status.
And what about this physical?
Kidney injury is resolved
My lord.
and acute stress disorder. This is something
My lord, these are not
which is,
physical injuries.
which
My
is
lord. My
connected.
lordship will kindly have a look
Physical
at-
injury is there
My lord.
and hypertension.
My lord,
Physical injury is there.
entire body, my lord.
See,
They will try to protect their officers.
multiple bruises, marks in the back of thorax and lumbar region, bilateral thighs and
My
gullet.
lord,
This there.
this is very vague. My lord,
It's
what?
there.
My lord, bruising injury can be of different types, my lord. Well, that is why I pray.
No, this is examined by the doctor. Medical,
I'm not
medical
from there. What I'm saying is, my lord, unless your lordship directs an inquiry by an
No, we just
independent
cannot.
body, let there be
For that, sir, we'll have to hear you. Hear all
no,
of
my
you.
lord, what I'm saying is, my lord, I'm not asking your lordship to take any decision today.
Hmm.
I'm only asking that present condition should be ascertained. My lord, there is an anxiety from the part of the honorable court also that what is the present condition? These reports
This
are
is the
not
present
correct.
condition.
My lord, bruises which they have said is a absolutely vague term.
No, that is physical examination.
My lord,
And then
my lord, let them take.
current impression is acute distress disorder, acute kidney injury.
My lord.
That is resolved.
My lord.
I don't know what does it mean, resolved within
Yes,
bracket.
that is why I'm saying.
Hypertension.
Well, the hypertension is not the reason for which the petition has come before lordship. My lord, there are acute physical injuries, my lord.
Yes.
A third degree method has
That
been
will
applied.
provide in the meantime. We'll provide them to provide.
No, I'm not on treatment, my lord. Treatment they will provide you. The hospital is there. What I'm on is, my lord, present to ascertain the present condition. To what extent the injury was caused, that has not come up. What I pray, my lord, let an independent body of two, three doctors make an inquiry.
This is
and
by
submit it.
board, consists of 3 doctors.
My lord, these reports are not vague.
We'll examine.
And let them take a photograph also, my lord. Lordship may direct them to take today's photograph. What is condition?
So
Otherwise, they will hide
we'll
everything.
examine. They have filed submitted report. We have seen it, and we'll examine. We'll adjudicate, determine it.
My lord, they will hide the entire condition, my lord. And these officers, they are only protecting their own officer.
Yes, that we'll see. They will see. We'll consider that. We'll determine that.
Because unless that present condition is before your lordship,
yes,
your lordship will not be able to ascertain whether the report is correct or not. That's what my anxiety, my lord.
List this matter after when 2 weeks or after a week, 10 days.
2 weeks, lordship. So that the medical examination report will be lordship.
Before that,
Lordship.
the petitioner be provided with required medical treatment
Facility.
by the respondent number 8.
A report may be produced, lordship, on next date, lordship. Reports may be produced on next
Let
date.
them file this in
You
the form of
file.
affidavit.
I have directed.
My lordship may direct them to file this report, etc. in the form of affidavit.
Bring on record. That is what I have directed already. The learned that I have said already that you should file it bring on record by way of affidavit. This report, whatever you want to file.
Lordship, medical report to be produced
Lordship
by
may just make
the
it-
Standing Council of the Health Department.
The report of the medical board is kept on record and marked as so and so. Document A.
And my lord, the direction was to the DGP. I do not know whether it has been filed by DGP or not.
DGP
If they are
is,
not following your lordship's order, because
We'll see.
DGP will be a responsible person, my lord.
We'll see on that day. This is under the direction of the DGP. Inquiry is conducted and accordingly report has been submitted.
Reports, man.
Inquiry report.
Lordship, when is the lordship fixing, man?
After 2 weeks.
Let's even
Where basically, so far as this case is concerned, will determine. But as of now, we're concerned about his health. That's
Yes.
why I've said, directed the respondent to provide required medical treatment.
And in fact,
Wherever he wants to, there's a recommendation that either he should be sent to Tezpur or some UPA or something, somewhere. Midpur somewhere. That will require medical treatment.
yes, man, wherever it is required, because kidney has suffered injury. He was a person who was in a fit condition, was taken to custody thereafter.
This
All
is
this.
normal process. Once you have that kind of thing, you'll have to go for all those treatment.
Lordship is fixing on 30th, man. 30.
After 2 weeks, lordship.
30.
30.
0520.
Okay.
Obliged.
Mayor, Your Lordship.
Yes.
Lordship, this is a case where the petitioner is praying for quashing of an FIR giving rise to usually PS case number 48 of 21, registered under section 417, 420, read with section 138 of Negotiable Instrument Act, Your Lordship.
Yes.
Here, Your Lordship, the facts of the case is that written complaint was submitted on 17/6/2021. Thereafter, registration FIR was registered. That is in page number 17, Your Lordship. Here, Your Lordship, the FIR, Your Lordship, the substance of the allegation is that FIR is in page number 70. It's a lengthy FIR, Your Lordship.
70?
17, page number 17.
15 or 17?
17, Your Lordship, page number. Annexure 1.
No, that is page 15. Annexure 1 is page 15.
Oh, sorry, Your Lordship, page 15, Your Lordship.
That is 17.
Lordship.
1706. Yes.
Lordship, here in the FIR, the substance of the allegation is that the petitioner had taken a loan. And after borrowing the loan, she failed to make the repayment, Your Lordship.
Yes.
And thereafter, she issued a check that was bounced. So main substance of the allegation is only regarding taking loan, and somehow she could not repay the loan amount. So, Your Lordship, the dispute here is purely a civil dispute, Your Lordship. FIR do not show any, FIR do not show that the petitioner had acted any dishonest or acted with deliberate intention to cause wrongful gain or wrongful loss, Your Lordship. Prima facie, no evidence, Your Lordship. The sections 417, 420 does not attract, Your Lordship. And my submission would be, Your Lordship, here, before that, Your Lordship, IO had registered the case, and thereafter, IO had filed an application before CGM for issuing a non-bailable warrant. That is in page number page number 21, Your Lordship. IO had made a prayer, Your Lordship, for issuing bailable warrant. And thereafter, the learned CGM had, that is next page, Your Lordship, by order dated 19/8/2021. Next page, that is in page number 22. The learned CGM had rejected the prayer of the IO, Your Lordship. And while rejecting the prayer, Your Lordship, learned CGM had made a finding, Your Lordship, that is in page number 23, the operative portion, the last para, Your Lordship, page 23. On perusal of the FIR, I find no prima facie case under section 417, 420 IPC. Moreover, the offense alleged to have committed are punishable with a term 7 years. And hence, I deem fit to direct the IO to first issue notice. And thereafter, Your Lordship, the IO, in compliance of this order, IO had issued a notice. On 2 occasions, the petitioner received a notice, Your Lordship, under section 41A of CRPC, Your Lordship. Here, the Lordship, the impugn FIR, Your Lordship, does not disclose any intention of cheating, Your Lordship. There's no any ingredients, Your Lordship. Here, Your Lordship, in order to fasten an accused a criminal liability, Your Lordship, the intention of dishonest is to be established. That has not been, there's no ingredients. The sections does not attract, Your Lordship.
It's a case of 138.
Yes, Your Lordship, 138. And unfortunately, the investigating agency, without application of judicious mind, Your Lordship, he had registered a case under section 138 also, Your Lordship. Because section 138 Negotiable Instrument Act is a dishonor of check, Your Lordship. Even section 142 of NI Act says, Your Lordship, except in written, complaint has to be in written, Your Lordship. Court cannot take cognizance, Your Lordship. Here, the IO had grossly misused the law, Your Lordship, by registering a case.
Yes.
Yes, Lordship, the section 138 will go. The only issue here is whether 417 and 420 is attracted.
This will also go.
Sorry, Your Lordship.
This will also go.
Yes, Your Lordship. On the bare perusal of the FIR itself, perhaps in my humble understanding, it's a mere breach of promise
Yes.
without there being any ingredient of
Which is a
dishonest,
civil dispute.
yes, dishonest or fraudulent intention.
Have you checked out, there's a 60 pages judgment I have delivered in a case of Nagaland. Find it out.
Okay.
On 420 and 416, 17, 415, 16 and all.
Yes, Your Lordship.
60 pages judgment.
Okay, Your
But basically it consists of the judgment of the Supreme Court.
yes, Your Lordship.
You find it out.
Okay, Your Lordship.
Your Lordship, here,
So is fairly here.
I have some
It's
citations.
a-
also, if you don't-
Just keep.
It's a very clear case, Your Lordship. In fact, I have the judgment pertains to Your Lordship to attract the section under 4, as Your Lordship has already highlighted the judgment passed.
Lordship,
This 420, Your Lordship, to hold a person guilty under section 420, it is the dishonest intention and
Give your
fraudulent
judgment
intention.
Your Lordship, I have given the list of books, Your Lordship. Your Lordship, first one is here in 2019-16 SSC 739. Ingredients was discussed, Your Lordship.
Well, I'll dispose of dictate the order in the
Yes,
chamber. You just give the
Yes,
citation.
I have already given Your Lordship the list of
You
books.
Your Lordship, in fact, all the citations are in their favor only, Your Lordship.
That's why you just give it.
Yes,
It's okay. Why to waste time, your time?
yes, absolutely.
So my humble prayer is, Your Lordship.
Yes, he's fairly,
Lordship.
Yes, I'm fairly
And also,
submitting.
Your Lordship, I would like to apprise this court.
Yeah.
The petitioner had resorted to civil remedies also.
NIA.
Code of action
Recorded.
was.
Recorded.
Lordship.
It is
I would like
stated
to
in the
please,
word. You have mentioned it in the petition.
No, this
No,
one,
it's a new development, Your Lordship.
after filing of this petition, they have,
Perhaps it's not required also, Your Lordship, because if it is not there,
Well,
if
just mention whatever her is.
Lordship.
It is stated in one paragraph, we'll see.
the stage is for filing of depositions.
Petitioner.
Petition.
may I mention the paragraph in the this judgment, Your Lordship?
Initiated civil proceedings by filing suit before the civil judge senior division at UP. Well, appropriately, will let.
Lordship.
Your Lordship, may I mention the paragraph in the?
Yes, yes.
Okay.
You also
Yes,
mentioned the
I have already
paragraph.
mentioned your Lordship, the
you give it all.
paragraphs.
We'll pass the order.
Lordship,
in the chamber.
I'm amicus. here, Your
Dispose. You are amicus.
Lordship.
Okay. Dispose of. How many judgment? One judgment.
Lordship, I have given 4, Your Lordship, ingredients, and then Your Lordship,
Which
Bhajanal also, Your Lordship, landmark judgment. Categories have let down.
Two, Your Lordship.
Yours, how many?
2 judgments, Your Lordship. Only 2 judgments.
I've given
We'll refer which is relevant also.
Lordship.
Yes, Your Lordship.
Not all the cases.
Yes, Your Lordship.